Welcome to the deep dive. Today, we're wading into a topic that, on the surface, seems incredibly technical.
Very technical.
We're talking about a set of proposed legal liability bills moving through the New York legislature, but we're here to show that these bills, if they get signed into law, have just enormous financial stakes.
Yeah, and they're tied directly to the crisis everyone in New York is talking about, which is, affordability.
Exactly.
It's a classic case of, well, legislative action meeting economic reality. When we talk about rising costs in New York, we usually think about taxes, right?
Right, or regulations, housing shortages, that kind of thing.
Exactly.
Yeah.
But these specific bills, which are now heading to Governor Kathy Hochul's desk, are drawing some really intense criticism. The opponents are claiming they're designed to dramatically increase the ease, the frequency, and just the sheer financial reward of suing the state.
And suing businesses operating there, too.
And businesses, yes.
And the core argument from the editorial we've analyzed is that this isn't just some political squabble between, lawyers and big corporations.
No, not at all.
If the risk of these massive, high-stakes payouts goes up, that cost, it doesn't just vanish into thin air.
Right.
That cost lands squarely on the average New Yorker in the form of higher insurance premiums across the board.
Exactly. That dynamic is so crucial to understand. Liability laws, they basically dictate how much risk insurers have to cover. So if lawmakers increase that liability risk, dramatically.
By, say, expanding who can sue or how much they can win.
Precisely. The insurers just adjust their pricing model. It's that simple. These huge payouts aren't just absorbed by some massive faceless company. They are instantly baked into the cost of doing business in the state.
And that gets passed directly to you.
To you.
And to give you a sense of why critics feel the legal environment is already, I think the term they used was out of control, the source opens with this just jaw-dropping anecdote.
Oh, yeah.
Just recently, a Bronx jury returned a $50 million award.
$50 million.
To a man named Darcy Botex. This was after he was reportedly clipped by a city garbage truck while crossing a major street, Bruckner Boulevard, while, and this is according to the reports, he was allegedly on his cell phone.
Yeah, and the sheer size of that award is what makes it so provocative. Botex claims the incident, which was in 2021, left him unable to work. But the editorial board is incredibly vocal about this. They call $50 million nuts.
Nuts.
And what's really galling to the critics is the idea that the award is so high, even though the source believes Botex shared at least some blame for crossing a busy street while, distracted.
Wait a second. If the plaintiff shared blame, doesn't that usually reduce the award? I mean, how do they even justify $50 million?
Well, that's where New York's current laws and these proposed expansions really come into play. While we do have comparative negligence laws, juries still have just immense power to decide damages.
And clearly, in some places like the Bronx, those awards are climbing fast.
Very fast. And the source argues that instead of looking for ways to introduce some sanity or maybe some caps to these damages, the legislature is doing the precise opposite. They're pushing bills that critics claim will only encourage more dubious lawsuits and inflate these awards even further.
It really sets the stage perfectly. I mean, this isn't a theoretical debate.
Right.
It's being measured in millions of dollars in these highly publicized verdicts.
So our mission today is pretty clear. We're going to unpack the specific bills the source is warning about, detail what they do, and then analyze the claims about the devastating economic damage they could inflict if Governor Hochul signs them into law.
Okay, let's unpack this and maybe start with some of the hard numbers.
Let's do it.
This is where the conversation gets really concrete. The data points critics are citing to argue that New York's legal regime is already, deeply out of whack.
Right. We're talking about the state's reputation for litigation risk.
And that reputation is now, I guess you'd say, formalized.
It is. For instance, the American Tort Reform Association, or ATRA, recently listed New York City as the nation's second worst judicial hellhole.
Judicial hellhole. That sounds dramatic.
It is dramatic, but it's a designation meant to signal to businesses, national and global ones, that New York courts are unpredictable, often anti-defendant, and just prone to these massive jury verdicts.
And what's the actual financial consequence of having this hellhole environment?
Well, according to findings that the source cites, this excessive litigation has claimed to cost taxpayers and companies in New York a staggering $89 billion a year.
$49 billion.
A year. It's a gigantic sort of silent tax on the economy that you just don't hear about in the headlines.
Wow. $89 billion. That number is so large it's almost hard to grasp. Let's bring it down to the individual level because this is where it hits home for you, the listener.
Right, this is the cost transference we were talking about.
The Partnership for New York City has done research showing exactly how this litigation risk translates into your monthly bills.
And the numbers are striking. Across the board, New York insurance premiums average 15% higher than the rest of the country.
15%.
Yeah, and if you look specifically at health insurance, those premiums are 12% higher. These are significant costs just for living in the state.
But the number that really jumps off the page, and the one the source keeps emphasizing as proof the system is broken, is auto coverage.
It's astonishing, isn't it?
It really is.
Auto coverage is a whopping 52% higher in New York compared to the national average.
52%. I mean, think about what that means for a working family. Maybe a family with 2 or 3 drivers. They're paying thousands more a year just to legally operate a car.
It's essentially a massive penalty on every single driver in the state. If you're paying that much more, it just means the entire system is priced to cover huge potential losses.
And the source argues those losses are driven by the high risk of being sued for what they call insane damages, like that $50 million Bronx verdict we mentioned.
And this is where the narrative tension the editorial highlights becomes almost absurd.
How so?
Well, while this data on crippling insurance costs is widely known, you have Democratic state senators Jamal Bailey, Brian Kavanaugh, and James Skoufis holding a public hearing to investigate high insurance costs.
I mean, that sounds like a good thing on the surface, right? Investigating high costs.
Sounds good, but the source is suggesting this is almost a distraction. The critique is that it's an unnecessary investigation because the cause is, to critics, abundantly and explicitly clear.
Okay.
If you increase the risk of massive, often questionable payouts, which the legislature has done and is actively proposing to expand, you force the premiums up to cover that risk. You can't seriously investigate high insurance costs without first investigating the liability risk and the legislation sitting on the governor's desk right now.
So the editorial is basically saying the problem is literally standing right behind you.
That's it, exactly.
That's fascinating. So the lawmakers who are supposedly investigating the problem are, in the eyes of the critics, the same ones actively making the problem worse by pushing these bills.
It completely undercuts the whole narrative of protecting consumers.
So this takes us directly to the 4 pieces of legislation that the editorial argues would actively encourage frivolous lawsuits and fraud.
Right. These bills are the concrete mechanisms that critics say would inflate that $89 billion annual cost even further.
Okay, we need to go through each of these 4 bills because they really change who can be sued, where they can be sued, and how quickly things can be settled. Let's start with the one sponsored by Senator Skoufis. That's Bill S5170.
S5170 is critical because it fundamentally alters the landscape of liability for third parties. Essentially, what this bill does is it allows a plaintiff to recover damages directly from a third-party defendant.
How is that different from the way it is now?
Well, currently, if someone is injured, they sue the primary party responsible. S5170, according to the source's interpretation, makes it easier for trial lawyers to use something called joint and several liability against sort of peripheral players.
Let's unpack that term, joint and several liability. Why should the listener care about that?
You should care because it means that if you are only, say, 5% responsible for an accident, but you have the deepest pockets.
Meaning you have high insurance or you're a big company.
Exactly. You can be forced to pay 100% of the damages if the main culprit can't pay their share.
Wow.
The consequence, as the source claims, is that people or companies who did little or nothing wrong are put at this elevated, really unfair risk of having to pay for someone else's wrongdoing. It's a mechanism that seems designed to ensure the maximum payout, regardless of who is actually at fault.
That dramatically shifts the risk calculation for every single business in the state.
It absolutely does. Which brings us to the second bill, S8186. This one focuses on jurisdiction and foreign corporations.
This sounds like a legal technicality, but I can see how it would have huge implications for, like, global commerce. What does it do?
This bill would force foreign corporations that want to do any kind of business in the Empire State to consent to what's called automatic jurisdiction.
So when they register to do business, they just waive the right to argue about where they can be sued?
That's pretty much it. So if a company registers to sell shoes in a Manhattan store, they're automatically subject to New York courts for any lawsuit.
Any lawsuit at all.
The consequence, as claimed by critics, is that it exposes them to lawsuits in New York courts, regardless of where the incident actually happened, whether it was in Europe or Asia or even another U.S. state.
So the fear is that plaintiffs' lawyers will just shop for the most expensive jurisdiction, which would be New York, even if the case has minimal ties to the state.
Precisely. It massively expands New York's legal reach.
Okay, now let's talk about the bill that's become the most contentious, the one the governor has already signaled she doesn't support, the Grieving Families Act.
Right, the Grieving Families Act is notorious. Governor Hochul has reportedly vetoed this exact bill for 3 years in a row.
3 years.
Yeah, which just signals how high the stakes are and how contentious the cost implications are.
So why does this bill cause so much fear when it comes to liability?
Well, it dramatically expands liability for damages in wrongful death cases.
Yeah.
Currently, wrongful death compensation is focused mainly on economic losses, lost wages, medical bills, that sort of thing. This bill would expand that compensation to include things like grief and emotional distress. It also gives plaintiffs up to 3 years to file a suit, which is an expansion of the filing window, and it significantly widens the scope of who can actually sue, including, non-immediate family members.
So if you expand the types of damages from purely economic loss to something like emotional distress, that dramatically increases the potential size of the awards, right?
Absolutely. The source's warning is clear on this. When you allow intangible damages like grief to be compensated, the potential award size just skyrockets. It makes litigation against hospitals, transit authorities, any entity responsible for a death incredibly expensive and unpredictable.
And that's why the governor keeps vetoing it.
It seems so. The state's own financial advisors are apparently warning about catastrophic budget implications.
Okay, finally, let's look at Bill A8706. This one changes the timing of settlement negotiations. It seems almost procedural, but the claimed consequences are pretty significant.
Right. A8706 would ban companies or individuals from negotiating a settlement with an injured party until 30 days after the event occurred.
30 days. That sounds like it prevents a quick, clean resolution.
That is the core critique from the editorial board. In many minor cases, an insurance company or a business could quickly offer a fair settlement that covers medical bills or lost wages right away.
Often without lawyers getting involved.
Exactly. By legally banning that immediate negotiation for 30 days, the editorial argues the bill is actively pushing claimants toward litigation.
So instead of a quick, say, $5,000 settlement, the person is just sitting for a month, giving them plenty of time to hire a lawyer who then naturally escalates the claim, turning it into a $50,000 or $100,000 lawsuit.
Precisely. The claim is that the delay is a tool designed to increase the involvement and ultimately the fees collected by trial lawyers rather than helping the consumer resolve things quickly.
So if we connect all these individual bills to the bigger picture.
Well, the source argues these aren't just technical legal reforms. It's an editorial, so they're pretty blunt. They represent gifts to skeezy lawyers.
Ooh.
Yeah. The position is that this is a deliberate legislative attempt to enrich one very specific part of the economy, the trial bar, at the expense of everybody else.
That establishes a very clear line between the winners and the payers. So let's be explicit. Who does the editorial say comes out ahead here?
The explicit winners, according to this critique, are the trial lawyers who stand to rake in piles of cash off even the most dubious lawsuits. This legislation, in the critics' eyes, guarantees more cases, expanded liability theories, broader geographic reach, and hugely inflated potential rewards.
And who ultimately pays for all this? For the increased risk, the successful lawsuits, the massive awards.
The payers are everybody else.
Right.
Or specifically New Yorkers, who the source warns will pay through the nose. The critique points out that lawmakers are actively increasing the cost of living with what they call this lunacy. They're ensuring the risk associated with everything from running a city garbage truck to stocking a retail shelf goes up exponentially.
And this is why the source finds the political commentary so frustrating. You see state leaders constantly talking about what government should do to increase affordability.
All the time.
But critics argue these legislative actions directly contradict that goal. They inflate costs across health, auto, general insurance markets. The two political narratives just don't line up.
It's a compelling charge. The editorial board is demanding Governor Hochul veto these bills. The argument is that she cannot seriously talk about making New York affordable while simultaneously increasing the risk and the magnitude of legal liability for every single resident and business.
She's the final stop.
She's the final stop to prevent New Yorkers from bearing this, what they see as a massive financial burden.
So what does this all mean for you? It means that when you get that notice about your auto insurance premium going up, that 52% higher rate we talked about, the issue might not be global inflation or some act of God.
Hmm.
It might be directly traceable back to decisions made right there in the state house about who can sue whom, for how much, and under what conditions. These seemingly small legislative changes have a massive financial gravity.
We've laid out the arguments, the cited financial data, that $89 billion cost, the 52% auto premium hike, and we've detailed the specific concerns of the bills the editorial board is targeting, from the third-party liability expansion in S5170
And the foreign jurisdiction in SA 186?
to the contentious, vetoed Grieving Families Act, and that ban on immediate settlements, A8 706.
It's a complex and I think fascinating snapshot of a debate over legal reform that pits this desire to increase consumer access to litigation and generous compensation against the escalating real-world costs that businesses and everyday New Yorkers claim they just can't afford.
Right. And knowledge is most valuable when you understand it and can apply it. We've defined the central tension here, and it really raises an important question for you to consider.
Go on.
If the source claims that lawmakers are talking about increasing affordability while allegedly supporting bills that increase living costs, how should the government truly balance the moral goal of ensuring generous compensation for the injured with the necessity of keeping the state economically accessible for everyone?
That balance point.
That balance point is the key calculation. It affects every policy decision and ultimately your wallet.